some not have tos, but some really important things that every contract should have. And I won't belabor these, but every contractor should have in their contract the right to supplement the claim, because that's really important. Claims are often undervalued by the insurance company, maybe on purpose, maybe not. But the owner needs to give the contractor permission to supplement the claims and to cooperate in that process. Overhead and profit is a giant issue with storm restoration. And there needs to be an acknowledgement that the contractor is a general contractor and therefore entitled to overhead and profit. That's very important. Authorization to contact the adjuster to discuss price and scope. Most all states allow interaction with the adjuster and the contractor to talk about price and scope, but it needs to be in the contract because the owner has to give permission in order for the adjuster to be able to speak. Change orders. I'm a big fan of a provision in the contract that says if you ask me to do something, whether or not it's reduced to writing, you're going to have to pay for it, because there's, disputes over change orders is one of the most common disputes there are in construction. And that is certainly true of non-restoration contractors, but it's true of restoration contractors as well. Exclusions, make sure that your contract says I'm not going to be responsible for gas lines within 3 inches or 6 inches of the underneath of the deck or whatever the case may be. Roof sags, damage by other contractors, nail pops, damage to, shrubbery or whatever. You need to set forth in the contract what you are and are not going to be responsible for. Mold is a big thing. If somebody finds mold, who's responsible for that? Assignment of benefits and assignment of claims is a hot topic across the nation. In Texas, there's no such thing. In Florida, I think they've basically phased that out. But in a lot of states, an owner has the right to assign their benefits and their claim to the contractor. And if that's the case, it needs to be very carefully written to comply with the statute. And so that's, whether that's a separate document or whether that's inside the contract, that's really important. Warranties, and we talked a little bit about that, but I'm a big believer that the owner is not entitled to a warranty until the contractor's been paid in full. And then, is the warranty transferable? Is it not transferable? Personally, I'm not a fan of transferable warranties, because part of agreeing to provide someone a warranty is you vetted that customer and you agreed that you're going to work with that customer, and now that warranty is transferred to a stranger, and that stranger could be crazy, unrealistic, whatever the case may be, right?
Right.
Arbitration or litigation is a big, big thing. And I always tell my clients, if it's you versus a homeowner, you do not want to be in court, because that jury, half of them maybe have been homeowners, but none of them likely have been a contractor. Right. And they're just a bias. Right. So you want to make sure that you are, that you're in arbitration whenever possible. And there are statutory requirements for enforceability of arbitration agreements. You want to waive a jury trial. Attorney's fees and interest. I think you should always have the attorney's fees and interest clearly spelled out in the contract, because in some states, if it's not in the contract, you don't get it. In Texas, for some reason, you can get it against an individual or a corporation, but you can't get it against an LLC or an LTD or anything else unless it's in the contract. So it's really important, because unfortunately, litigation is very expensive, and there's nothing worse than at the end of that process to find out that you won, but it cost you so much to win that you really didn't win anything at the end of the day, because those fees are not recoverable, and that's just a shame. Right to stop work if not being paid, right to repair work, and then advertising, the right to advertise, right to take pictures, right, is really helpful. And then, yeah, all the disclaimers and all that stuff. So sorry, I just had to get that